Okay, Marcus Robinson is here with us today, and he's going to talk about the closing of Richmond Heights Elementary. Marcus, the first thing I need to let you know is that we are recording this, and it will appear on some social sites, probably YouTube and some other things. You're okay with that?
Yeah, no problem.
Okay. Marcus, we know that you are heavily involved in this Richmond Heights closing issue with District 5 School Board member Kat Gordon and the whole school board situation. Tell us in detail how this all got started and how we got to this point where we are now with the closing of Richmond Heights Elementary.
Well, one of the first things you have to do is start back in 1962 when Orange County at that time was a segregated school system, and there was 8 black great families that actually took Orange County School to the U.S. District Court to integrate the school system because they wanted a fair educational system in Orange County, and that you weren't getting that. And so you have to salute those 8 black families that actually sued Orange County that started this process. Then from there, from 1962, you went to 1964. Well, finally, the Orange County Public Schools submits its desegregation plan to the courts. And at the same time, when they did that, they put a component called a biracial committee, which was made up of 5 black and 5 white. And this group was to approve any decisions that changed the transfer policies, attendance zones, or school locations within Orange County Public Schools. So this was more of an oversight type of committee that monitored Orange County Public Schools desegregation plan. So that's what actually started the process in integrating Orange County Public Schools. That plan in 1964.
Okay. All right, go ahead now. So they created the biracial committee, 5 blacks, 5 whites to do this.
Correct.
Okay. So what happened next?
Well, as the litigation goes on from 1964, there's some changes in the desegregation plan, some modifications. You had from 64 to I believe 67 to maybe 2001. You had some changes, some modifications to that original desegregation plan, but almost for 40 years there hadn't been anything that was going on from a legal point that NAACP Legal Defense Fund challenged Orange County on anything.
Okay, wait a minute.
So,
40 years they didn't challenge anything. The NAACP challenged nothing. They found nothing wrong at all in the school system.
Right, and one thing you have to understand that the NAACP Legal Defense Fund and NAACP are total different entities, and this is one thing that I had as I did my research to find out that the NAACP Legal Defense Fund and the legal NAACP are totally different.
Okay.
So the NAACP Legal Defense Fund over a 40-year period hadn't done anything or challenged anything based on what Orange County was doing per the desegregation lawsuit.
Okay, so the NAACP Defense Fund is out of Maryland, is that right?
No, the NAACP Legal Defense Fund is out of New York City.
New York City. Okay, so they had. Right. How would they know what's going on down here?
Well, that is the job of the attorneys, is to monitor any changes going to the desegregation plan, any type of changes through construction, zoning, transfer policies, etc. That is one of the mechanisms is they both notify the Legal Defense Fund on those changes, plus the biracial committee is another mechanism that supposed to be notified if Orange County makes any of those changes. Virtually almost 40 years, they was uncontested of any operation of the desegregation plan. And so that's what went on for the next 40 years. in February 2009, actually Orange County had a workshop, and they had these workshops quite often, different type of workshops, but they had this workshop. I think the basis of this workshop was trying to figure out at that time how Orange County could save money. How could they save money when they felt that they didn't believe that it was going to get funding from federal government, state, et cetera, et cetera. So that workshop, they looked at proposals, different type of proposal plans to try to save money. And Kat Gordon on District 5, she out of all of the school board representatives, she made a proposal that was willing to sacrifice some of her schools in her districts to close. They used the word merger, but when you merge anything, the thing that you're not merging to, that is being closed. So one of her proposal plans, again, this was February 9th, 2009, that the merger plan was one of the plans were either to merge Eccleston Elementary and Carver to develop a K-8 school. One was to merge Richmond Heights Elementary School with Eccleston. Another plan was to merge Orange County Elementary School with Lake Elementary. Another one was to merge Washington Shores Elementary with Ivy Lane Elementary or Orange Center Elementary. Another one was to move Grand Avenue Elementary to Orlando Tech Center.
All right, so in all of Orange County, Kat Gordon in District 5 is the only school board representative who stepped up and decided to give up some of the black schools, give up some of the schools in order to save Orange County funds.
Correct. That she was the only one at that workshop February 9th that proposed to do this type of closure of our schools to save Orange County Public Schools money. And if I can recall in the minutes, she said that she wanted to lead the way, to be the example for our district and be the example that other districts can follow.
Yeah.
So we would be basically the sacrificial lamb. Our schools would be the sacrificial lamb, and hoping that other districts follow behind us, which they did.
Of course not. Well, why would they?
Right.
Okay.
Exactly.
All right, so why didn't this plan go through?
Well, what had happened was anytime that they was talking about closing the school, because since Orange County Public Schools was still under the desegregation lawsuit, they still had to get approval from the biracial committee. Now, the biracial committee, as I said, the biracial committee consists of 5 blacks and 5 whites, and that committee handles any time that you want to make changes, transfer policies, attendance zones, school locations, etc., that you have to get the approval of the biracial committee, which the biracial committee is a federal court order to approve any decisions. So they're not just there; they have to approve any decisions. Well, Orange County Public Schools has stated that they had got the approval of the biracial committee, and they was actually going to move forward with Kat Gordon's proposal. Orlando Sentinel on April 8th, 2009, Orlando Sentinel exposed that the biracial committee, the meeting that they supposedly approved to go forward with the Kat Gordon plan, they say that they had got the approval of the biracial committee. When the Orlando Sentinel exposed it, found out that at that particular meeting, there was only one person in attendance. It was a white male. He was in attendance, and he had given the approval all by himself. This is a violation.
Do we know who this person? Do we know who this person is?
I don't have his name on the top of my tongue, but
but we could find him and talk to him, right?
Yeah, but it's the purpose to talk to him about what?
Exactly.
He admitted that he voted for it because they got the minutes to say that he voted to go ahead with that Gordon proposed plan.
All right.
So he turned around, and once that was exposed, then Orange County Public Schools, the lead attorney for Orange County Public Schools, Crockenbach, director start doing Operation Cleanup. Everybody played the dumb role. They didn't know this. How could this happen? Even Ms. Gordon even mentioned, how could this happen? This is a tragedy.
Wow.
All of these things, but yet they knew that that the biracial committee didn't have a quorum to vote, but they figured no one was going to expose it, and so once it got exposed by the Orlando Sentinel, they put that to the side. They put Kat Gordon proposal to the side for now because they were embarrassed that this was going to happen, and that they didn't do their due diligence. So they put that proposal to the side, and they concentrated back on getting Orange County off of the desegregation order.
All right, so
and,
I'm sorry, go ahead.
Yeah, and so as that went forward, they concentrated on the desegregation lawsuit. They start talking with the local branch of the NAACP to see how they can work with getting Orange County off the desegregation lawsuit. Some deals were made, some handshakes. There was some behind doors deals that were made to push this agenda to get Orange County Public Schools off of the desegregation lawsuit.
Okay.
I remember hearing quotes saying, it's time. Time. It's been 40, 50 years. It's time for us to move forward. Things have gotten better, et cetera, et cetera. These are the things that they were saying, and yet it wasn't true. We know that the desegregation order, to get off the desegregation order to get what they call unitary status, that you have to have a fair and equal school system throughout every school in Orange County Public Schools.
Right.
But we see that blacks are bused to white schools, white kids aren't bused to black schools.
Right.
As long as blacks think that there's a inferiority in black schools and a superiority in white schools, then you can't get unitary status, because part of getting unitary status is that the mindsets of the school system overall has to change.
Right.
Black kids have to think that going to a black school is just as good as going to a white school. And if a white school, if the mentality is that going to a white school is better, then obviously there is something faulty in the system that makes a child think that.
Right.
Our parents think that. And this was stated not by Marcus Robinson, this is stated by the Supreme Court.
Right.
That if there is any time that a child or parent thinks that going to a minority school is an inferiority school just on the basis that it's black, and that going to a white school, a majority white school, they get a better education, that means the school system has failed and yet hadn't met unitary status.
Right.
So, but they pushed this, and they pushed to get off of the desegregation, again, with deals that were made and incompetence by the attorneys up in New York, and friendships and handshakes that were made with the local NAACP, and the desegregation order was dismissed on August 2nd, 2010.
Right.
And Orange County was declared unitary status.
Which, of course, we all knew that it was not.
Correct. Based on the definition of the criteria to meet unitary status, yes, it didn't meet it.
Okay. All right, so what was the next thing? The settlement agreement issue?
Yeah, well, what they did was after they came to the segregation, after that was dismissed, Orange County finally approved what they call the settlement agreement. The settlement agreement is basically a guideline, an agreement for Orange County Public Schools to take certain mandates and provide certain reporting as it pertains to facilities, retention, recruitment of faculty, and extra curriculum. So this agreement was approved by Orange County Public Schools on October 12th, 2010.
Okay. Settlement agreement. Okay, so then in September, you still have the Unitary Status Oversight Committee that ensured the OCPS compliance. What was going on with that?
Correct. Well, what they did was this is part of the game. Even though that they had formed the settlement agreement back in October 12th, they took almost a year before they put the Unitary Status Oversight Committee together to approve that. And that committee is to ensure the Orange County Public Schools is compliance with the terms of the settlement agreement. So the settlement agreement had been in existence since October 12, 2010. So who's been to ensure that OCP is in compliance with the terms of the settlement agreement are being undertaken in good faith? If the settlement agreement had been in action since October 12, 2010, and you didn't come to form the Unitary Status Oversight Committee till September 27th. So it's almost been 12 months that settlement agreement has been working without any oversight.
Wow.
Now, what they turn around and do, on the same day that they formed this Unitary Status Oversight Committee, because they want to make sure that they had this in place before they would suggest to close Richmond Heights, on the same date that they approved, the Orange County Public Schools approved the Oversight Committee, they turn around and approve a timeline to consider consolidation of Eccleston and Richmond Heights Elementary School. So they made sure that their I's were dotted and T's were crossed. They knew they couldn't do a proposal of a timeline to consider the closing of Richmond Heights Elementary School. First, they had to make sure that the Oversight Committee was set up first.
Right.
Then they could do that. So they made sure they did that first. Then, based on the settlement agreement states that anytime that they propose to close the school that's listed in the agreement, they must notify the Orange County chapter of the NAACP and the Legal Defense Fund in New York to let them know that this is their proposal to close the school that's listed in the agreement. And so they did that on the very next day, on September 28th.
Mm-hmm.
After they formed the Unitary Status Committee on the 27th, they approved the timeline to consider the closing of Richmond Heights, and on the September 28th, they sent the letter out to the NAACP, Orange County chapter, and the Legal Defense Fund up in New York City.
Okay. All right. So then they needed to meet with the NAACP Executive Board.
Well, they didn't need to. What happened was they actually, Orange County Public Schools, went over and beyond, because the settlement agreement states the only thing they have to do is send them a notice in writing about the closing of a school. They went over and beyond and actually went to the NAACP Executive Board meeting on October 10th, 2011, and they met with the Executive Board that told them what they were planning on doing, and kind of gave them a sing and dance show, tell them how great it was going to be, et cetera, to basically get the NAACP approval, even though based on the settlement agreement they didn't need their approval, but they didn't want the NAACP to be against it. They didn't want the NAACP to speak against what they were doing. So they went there and, shook hands, kissed faces, and all of that stuff. And basically the NAACP bought into what Orange County Public Schools, what Kathleen Gordon and the rest of the staff from Orange County was selling. The NAACP Executive Board bought it without any resistance. They didn't ask any questions. They didn't even ask to show us some reports why should the school be closed, and give some tangible evidence to justify the closing of Richmond Heights Elementary School. Because based on the settlement agreement, that the only way that you can close a school that's listed in the agreement, that Orange County Public Schools has to have a dramatic revenue shortfall. It has to have a dramatic revenue shortfall to close any school that's listed in the settlement agreement.
Right.
The NAACP Executive Board obviously didn't read the settlement agreement because they didn't ask the question. The question was never brought up from the NAACP, and so they moved forward with it.
So they went on and decided to close the school.
Well, after that, meeting, they had another meeting, which was October 19th. That was the first meeting of the Unitary Status Advisory Oversight Committee, the committee that they just formed on September 27th, that they finally have the first meeting. And again, like I said, that this group, its job is to ensure that Orange County Public Schools is compliance with the settlement agreement, and they undertake it in good faith. So if they were in compliance to make sure Orange County is in compliance with the settlement agreement, then they would have brought up the issue that the only way that you can close a school listed in the agreement is that Orange County has to have a dramatic revenue shortfall. That is the only reason that you can.
And they didn't have that.
They didn't have that based on the chief financial officer, which I have in writing from him. I asked him that particular question. The chief financial officer, Richard Collins, said no, there wasn't a dramatic revenue shortfall. He said that it would have been a dramatic revenue shortfall if the citizens of Orange County wouldn't have voted to increase the millage. But since citizens of Orange County voted to increase the millage, there was only a slight reduction in revenue. The settlement agreement says that it has to be a dramatic. And like I've told people, that Orange County is the 10th largest school district in the country.
Right.
If you had a dramatic revenue shortfall, you're going to propose to close more than one school.
Right.
But Orange County, 2011-2012 school year, only proposed to close one elementary school.
And that was Richmond Heights.
And again, if you had a dramatic revenue shortfall, if that was true, you would close more than one elementary school. It may only save you $1 million in operation costs. And that's all the elementary school would save you is $1 million in operation costs.
All right. So it looks to me like they tried back in 2009, Kat Gordon tried back in 2009 to close or merge these other 6 or so schools, and Orlando Sentinel caught that, stopped that, and so now it looks like one by one they're trying to do it again.
Exactly, and that's what it looks like, because one of the things that when they voted to close the school on October 25th, it was a 5-3 vote, of course. Kat Gordon, Nancy Robinson, Joey Cato, Christine Moore, and Darryl Flynn voted to close the school, and the only people that voted to keep the school open was Chairman Bill Sublett, Rick Roach, and Vicki Bell. Now, by them voting to close the school, their whole arguments were that they had low enrollment and they didn't have any technology. Well, when you actually get past all the smoke that they were saying, you find out that there's almost 120 kids that live less than a mile away from Richmond Heights Elementary School are being zoned. And I try to tell people, not transferred, not people who got a different type of transfer, but when a neighborhood is zoned, that means everybody in that area goes to a particular school.
Right.
And when you're zoning kids in Richmond Estates to go to Persian Elementary School, and you got kids, all the kids that go to live in Crossroads Apartments or LD, they're zoned to go to Palm Lake Elementary School, then you turn around and say that Richmond Heights has low enrollment. Well, when you're busing almost 120 kids out of the neighborhood to go to other schools, then that's easier to justify.
Mm-hmm.
You know, and they turned around and said, well, they don't have technology. Well, when we did a public records request and compared the technology at Richmond Heights Elementary School with that of Millennium Elementary School, Richmond Heights Elementary School has everything that Millennium has. They may have a newer building, but the technology is still the same. They still have 3 to 4 computers per classroom. They have the Parmentian or smart chalkboard in the classroom. They have the LCD projectors in the classroom. They have 2 computer labs in the classroom. Richmond Heights even have a mobile computer lab that has 26 notebook computers on it. So that's
all right. So Orange County is Orange County School Board is saying that these problems exist when they really don't, and they're using those false problems to close the school.
Well, that was the talking points of Kat Gordon and the people that followed her.
Uh-huh.
The people who voted not to close the school. They didn't believe that, or they were more looking for solutions to the problem and not just accepting the problem. So
but the school board itself could solve those problems if it chose to.
If those problems were true.
Right.
If they didn't have technology, then the question should have been, Ms. Gordon, is in your school district, how long have they been without technology?
Right.
And if they were without technology, why hadn't you made sure that Arctic had the technology as other schools? If that was true, but we found out it wasn't true. But that's one of the questions that should have been asked. The other question should have been asked, Ms. Gordon, if it's low enrollment, then why are you still allowing or haven't brought up the fact that we have over 120 kids being zoned out of our neighborhood to go to other schools to make sure their enrollment numbers are up?
Right. If they could use those excuses to close Richmond Heights and other elementary schools, they could use that excuse, manufacture an excuse to close Jones High or any other school they wanted to.
Well, unfortunately, Jones High has always been on the list for Orange County Public Schools.
Mm-hmm.
They had actually wanted to close Jones High back in the 60s, in the late 60s.
Uh-huh.
And black students actually protest about the closing of Jones High School. So the idea of that, Jones High could be in. Currently, Jones High is at 45% enrollment.
45%?
They get a public records request. First day of school, numbers for only 725 students. So what is the cutoff point before Orange County Public Schools suggest to close Jones High School if they can suggest to close Richmond Heights Elementary School because of low enrollment?
Right.
What is Jones High when it comes down to low enrollment?
Right.
High school is more expensive to run than an elementary school.
Right.
So Jones High is almost $3 to $4 million in red due to its low enrollment. So could Jones High be next? It's possible.
Mm-hmm.
I know I don't want it to happen, and we'll say they'll never do it, but I didn't say never. If you don't fight for anything, then it will happen.
Sure.
Because, they take your eyes off the prize.
Thank you very much. We're running out of time. I appreciate your time, and we'll continue this and talk about that football field and a couple other things the next time around, okay?
Okay.
All right. Thanks, Marcus.
All right. Bye-bye.
Bye-bye.